Good evening. My name is Neil Abramson. I am the Secretary of the Westview Ratepayers and the Chair of the Education Committee, which is providing this discussion of DRIPA tonight. There are two other members of the Education Committee. One is Robin Murray sitting back there. Raise your hand. And the other is Bob Hackett as well. And between the three of us, we have come up with this speaker. What am I doing here? What am I doing here?
Closer.
Sorry?
Speak closer into the mic.
Yeah, I speak closer into the mic. Andrew Gage is our guest tonight. He is a staff lawyer at the BC, the Westcoast Environmental Law Company. That's not right, is it?
Nonprofit.
Anyway, whatever. It's the thing.
Westcoast Environmental Law.
Westcoast Environmental Law, WCEB. And he is we are genuinely grateful. He is a replacement for Michael Bissonette, who was our original speaker, who last week was caught up in some terrible family problem situation, and he had to go and resolve that instead. So Andrew has come and filled the gap, stuck his finger in the dike so we didn't all drown here. And what this meeting is about something called DRIPA. DRIPA is the Declaration on the Rights of the Indigenous Peoples Act. It was passed unanimously by the British Columbia legislature in 2019. It is an act based on UNDRIP, which is a United Nations organization legislation that would have had no effect in Canada, except that the province of British Columbia made it official. And it gives Aboriginal peoples and their nations rights under the laws of British Columbia that they hadn't had in the past. And so what those laws are, what those legal rights are, what they're going to be, how they're going to be implemented, is all currently under discussion between the provincial governments and the Aboriginal nations. And Andrew has come to explain this to us, and hopefully he will talk about the meaning of DRIPA and about the implications for everybody in the province and the concerns that people might have, of which there might well be some, and the opportunities it will present for both Aboriginal and non-Aboriginal businesses and citizens. So that's the introduction. And now our president, Ray Craig, president of the Westview Ratepayers, has some things to enlighten us with.
Enlightenment here, but I just wanted to say this is the first event that's being organized by our education committee. We want to organize more. We want to identify issues that are of concern to the community and bring them forward. And in doing that, we want to do it in a balanced way. We want to be able to look at the issues in terms of the arguments for, the concerns about, provide a very balanced perspective so that you're able to analyze for yourself what you think. And that's what's going to drive the work we do. And this is just the first of many, I hope, that'll allow us to start to unpeel, all the dynamics around issues that affect us all, and see if we can understand the different perspectives that people have on them, better understand that, and then maybe we'll appreciate that, and then doing that, we'll be a better community. So that's where we're going, and I want to thank the Education Committee, and it's taken a bit of work to get this together, and thank you for being here.
I forgot one detail. I like that. There are cards and pens. You don't have to have them all right now, but there are cards and pens. The issue that we have is that we're not sure about the ability to come to the mic to ask questions, or whether if you ask them from the seat that Andrew will be able to hear them. He does have some questions that Rick gave him that he can start with, but you folks might well have questions too. And so I think what Sherry was thinking was that if you have a question, you can write it out on one of these cards. And then I guess I'm the one who gets to speak it into the mic, unless you're really insistent and come up here and wrestle the mic away, which will be easy to do.
It's a temperamental mic.
Oh, and it's a temperamental mic, so in the act of wrestling, you may be struck dumb. So is that it? Can I turn off the mic?
I think so. Oh,
Andrew, I think you're on.
Okay, thank you very much, Neil and Rick and everyone else who's made this possible. As they said, I'm Andrew Gage, been with Westcoast Environmental Law for over 20 years. I have colleagues who I had hoped would be the ones presenting this, who have a deeper experience in working directly with First Nations than I do. And Michael does extend his regrets, as Neil said. He was unavoidably detained. He wanted to be there in person. I would love to be there in person too, because who needs an excuse to go to Powell River? I mean, but just was not possible on the short notice and given my schedule. So thank you for accommodating me via Zoom, and I appreciate seeing so many people coming out to talk about these important issues. I'm going to share my screen now. Here we go. Okay. So yeah, we're here to talk about the Declaration on the Rights of the Indigenous Peoples Act and the Land Act amendments that recently caused controversy. As Neil said, this is based on the United Nations Declaration on the Rights of Indigenous People. This is a document that was originally adopted in 2007, but Canada initially did not endorse it and only endorsed it in 2016. That being said, both Canada and British Columbia have now enacted laws to implement UNDRIP into Canadian law. The intention here is to set out minimum standards for the survival, dignity, and well-being of Indigenous peoples, the Indigenous peoples of the world. So it's not intended to sort of be an onerous thing. It's most of the provisions. I don't know if anyone who here may have read it, but most of the articles are very much around ensuring that Indigenous people have access to decision-making, have access to their lands, can be involved in, can maintain their culture, and these sort of basic human rights obligations that we arguably already had. And in fact, I would disagree with Neil a bit when he said that this created new obligations. We're still working out where as I'll talk about later, where the boundaries of the legal obligations in relation to Indigenous people are in Canada. And despite having this been an issue since the beginning of the country and before, but there are very good arguments that many or all of the rights that are set out in UNDRIP are ones that are recognized in Canadian law. And certainly going forward, I think that UNDRIP will inform the interpretation of Aboriginal law in Canada. The Supreme Court of Canada recently noted that the declaration is not binding as a treaty. Actually, it's a resolution of the General Assembly. It's not a treaty at all. And even if it were, treaties are only become part of Canadian law once they are implemented by governments. But nonetheless, the court noted that states are taking on the obligation to, in consultation and cooperation with Indigenous peoples, to take appropriate measures, including legislative measures, to achieve the ends of the Declaration. That's what BC has done through the Declaration of the Rights of Indigenous Peoples Act. The Supreme Court was using the Canadian equivalent of that legislation in interpreting the Act respecting First Nations, Inuit, and Métis children, youth, and families. So we're seeing the courts take some first tentative steps into recognizing UNDRIP and the legislation that implements it in their decisions. So what I'd like to do is walk us through a bit of a history about Indigenous rights. I know many people there probably have some of this background. Um, this is a legal history. It's not just, so it's very much focused on what the law said and says, because that's important in understanding why the BC government, and for that matter, the Canadian government, have chosen to implement the UNDRIP through the provincial legislation and the federal legislation. Then we'll talk a bit about where that history of Indigenous legal rights leaves us in terms of what the current status of Indigenous rights are under Canadian law. And then we'll look at the BC DRIPA, the Declaration on the Rights of Indigenous Peoples Act, and the proposed Land Act amendments and the controversy that resulted from them. And I hope to persuade you that those changes that were proposed were not nearly as alarming as some politicians found it convenient to suggest they might be. So starting with our history. This is what British Columbia looked like in 1846 when Britain asserted its sovereignty over these lands. It's a map of the southwest of the province through European eyes at the time of the signing of the Columbia Treaty. And of course, it looks relatively empty and uniform across that, but there were a host of different language groups and nations that lived and occupied those lands and used them in a variety of ways that at that time. Now, in 1846, it was actually very clear that there were three main ways that the Britain could acquire sovereignty over lands. They could either find them completely unoccupied and just settle them. There's no people there. They could gain them by conquest through war, or they could sign treaties with the nations involved and acquire the sovereignty over the lands that way. Those are the only three ways that in 1846 the common law recognized to acquire sovereignty. Now, none of those happened in BC. We had a territory that was peopled by various peoples. There were a few skirmishes, but for the most part, there was no conquest. And with the exception of a handful of treaties that Sir James Douglas signed in the southwest of the province on Vancouver Island, and a later extension of the Treaty 8 into the northeast of the province, there were no treaties signed with any of the nations throughout BC. The Douglas treaties on Vancouver Island are interesting historically because Douglas seems to have believed that he needed to sign treaties in order to get sovereignty and to get the right to settle and to ensure that the lands would be available to settlers. That was certainly the view in the rest of Canada. Treaties were signed throughout the country, except for in British Columbia. However, Douglas also, the treaties that he negotiated were almost certainly not understood by the nations he was signing them with to be ceding their authority. And there's some evidence that they weren't even actually signed by the nations in questions, that once they were written up, someone went through and just put X's next to each of the chiefs' names that they recovered. So there's debate about whether these treaties legitimately indicated an intent to cede land to Britain. But regardless, they are the only treaties, with the exception again of Treaty 8, that were actually signed in this province, raising some very uncomfortable questions about exactly on what basis Canadian law even applies in Canada. Now, as a matter of fact, the Canadian law is here to stay. It's the de facto law of this country. I'm just raising this point to point out that the relations between First Nations and settler population from the very beginning of our province have been extremely messy. And the legal issues, it's not just that we've ignored Indigenous law and Indigenous legal systems, it's that we've ignored our own, the British laws that claimed to be the basis for this settlement. Now, while we can maybe gloss over the question of of how we have authority, it's also very clear that at the time that settlement of a land, whether through treaty or conquest, when there were people there, did not remove the existing rights or laws or legal institutions of the people who had ceded their land or had been conquered. Those laws under the British common law continue, and you can see countless examples around the world of legal structures where Indigenous legal systems in British colonies, former British colonies, continue to exist alongside the British legal system. Now they could potentially be repealed or replaced by the British system, the Canadian law, once the sovereignty has been asserted. But if they're not, and they have to be, that has to occur clearly. It can't just occur by accident or incidentally. Then those laws continue. Now, in the 1860s, 1880s, there was actually considerable disagreement among British officials over the importance of recognizing Aboriginal lands and signing treaties. As I mentioned, Sir James Douglas signed treaties, and when the funds ran out, he adopted a policy of adopting very expansive anticipatory reserves that were intended to ensure that First Nations would have enough lands not only for their current needs, but also for their future needs. However, the subsequent governor of British Columbia, Governor Trutch, rejected that, expressly disavowed those treaties, and took back most of the lands that were reserved. And from the 1870s onwards, First Nations were working very actively, often with lawyers, British trained lawyers, trying to assert their ownership of their lands and rights. In preparing for this, I was looking at the Tla'amin Nation's website, and they record the fact that in 1878 they took over a timber reserve and occupied a timber reserve that had been issued over their objections or without their knowledge, and containing one of their village sites. That village site was, despite their efforts, subsequently sold into private hands. So, that history goes back a long way. A couple of years later, in 1881, the Niska Nation sent a delegation all the way from the northwest of the province down to Victoria to protest this. And at one point, they had an opportunity to meet with the premier, who denied even knowing what treaties were when he met with them. So, despite the efforts of nations, there was ongoing encroachment and not a consistent approach to addressing the rights of Indigenous people. And in 1927, Canada banned First Nations from hiring lawyers to assert their legal rights unless they had permission from the federal government. So in 1949, First Nations finally gained the right to vote in provincial elections, and Frank Calder from the Niska Nation was elected as the first Indigenous MLA. And then 2 years later, that ban on hiring lawyers to assert their rights was repealed. And the MLA Frank Calder and other Niska leaders filed a lawsuit in 1967, asserting that they had title over a large area of the Nass Valley. The Supreme Court of Canada did not actually in the end rule on that. But three of the Supreme Court justices would have ruled that the Niska did have title. It continued to exist to that day. 3 would have ruled that it had been extinguished, that they had it, but it had been extinguished through gradual application of the Land Act and land grants. And then one judge ruled on a technicality. Well, it wasn't a technicality. It was a procedural point that existed at the time, that no one could bring a case of this type without permission from the government, and refused to rule on any of the issues whatsoever. So it was a tie, and left the issue unsettled. In 1982, the Constitution Act was amended, including recognizing existing Aboriginal and treaty rights. Interestingly enough, a lot of the government representatives who I think federally voted in favor of that and supported that amendment didn't actually know whether or not there were existing Aboriginal or treaty rights. But it was something that the First Nations had long been pressing for, and they were it was included. And what's followed is decades of litigation. I mean, really, we'd already seen litigation even before the charter provisions came into place, but decades of litigation by First Nations, often waiting years to have their issues resolved. I was 14 when the BC Supreme Court, my parents were interested in this controversy in the Victoria area, where the Tsawat Nation was fighting a marina that was proposed in the Saanich Inlet. The Tsawat Nation was one of the Douglas Treaty nations. They had a treaty saying that they had the right to fish as formerly, and they were very concerned that this marina was going to harm fishing in the area. And they went to court on the basis of their treaty. And I still remember, and this is stunning to me, that that controversy about whether to just ignore Aboriginal rights and pretend they don't exist, or to actually deal with them through the treaty, continued to permeate Canadian law even that late, because the lawyers for the province of British Columbia actually argued that the Douglas treaties were invalid because Douglas hadn't had authority from the Crown to sign the treaties. And I remember my mother, who had brought me there because she thought this is a historic thing I should be seeing, saying, but wouldn't that mean that all of Victoria belongs to the First Nations? I mean, the government of the day thought so little of the idea that First Nations title might continue to exist that they were willing to give up and actually argue against one of the few treaties that had been signed in the province. But that litigation's then continued. I mean, there's been a continual flow of cases, often taking years, even decades, to be resolved. The Delgamuukw case was filed in 1984 by the Wet'suwet'en and Gitxsan nations, asserting that they had Aboriginal title over large areas. They lost at trial at the BC Court of Appeal. They won an order that they had Aboriginal use rights, the rights to hunt and fish over large areas of their territory. But the Court of Appeal did not, narrowly ruled against finding that title had existed. And then the Supreme Court of Canada in 1997 confirmed that Aboriginal title continues to exist. It has never been extinguished. But found that in the case of the Delgamuukw case, the trial judge had not answered the right questions, and basically said an entirely new trial needed to occur to settle whether or not the Gitxsan and Wet'suwet'en had over what parts of their territory they have title. So we know they have title, but we don't know where, because they've negotiated since then. The Haida case, filed in 2000 and considered by the Supreme Court of Canada in 2004, comparatively speedy, concerned whether or not the province of BC could continue issuing forestry licenses to companies in Indigenous territory when these issues were unsettled. And the Supreme Court of Canada said that even though we didn't yet know where the Haida's title lands might be and what rights they had precisely, that the government of British Columbia, before it made these momentous decisions, had to consult the nations, and could not, the forest licenses were not valid if they had not consulted and tried to address concerns about the possible impacts of these forest licenses on the Haida's rights. The Chilcotin case, actually about the Hanigwitine nation within the Chilcotin Nation, was filed in 2007. It's the next title case that was filed, and one of the only ones really still to date, with a couple more recent ones, but a huge, the first successful title case. And the Supreme Court of Canada issued an order that the Hanigwitine had title over a significant area of their territory. And then finally, more recently, a treaty case, Yahi versus BC, concerned the incremental impact of oil and gas, forestry, and other industrial operations on the treaty rights of the Yahi Nation in northeastern BC. This is one of the Treaty 8 nations. They had a right to hunt and fish as formerly, and it was getting increasingly difficult to do that because the government just kept approving oil wells or logging or other impacts that was driving their the animals that they hunted out of the area or killing them. And those are just a few. What I want to get across is that really BC law was unsettled, has been a history of trying to rectify this original wrong, this original failure to actually do right by nations and to protect their rights at the beginning of the founding of BC. And that continues. So the current status of Indigenous rights in Canada, I'm not going to go through the cases, but we'll just talk at a high level about some of the concepts. First of all, Aboriginal title and rights continue to exist and are protected by the Constitution Act of 1982. The title lands extend to all lands regularly used for hunting, fishing, or otherwise exploiting resources, and over which the group exercised effective control at the time of assertion of European sovereignty. This is important because the BC Court of Appeal in this case had said that no, those lands are limited to the actual village sites and should be taken very narrowly. The trial judge, the original judge of the BC Supreme Court had rejected that and criticized that as a postage stamp theory of Aboriginal title. The Supreme Court of Canada agreed with the original trial judge, said, no, you're not limiting it just to these tiny areas. These are significant areas that many of these nations had control over. And if they don't have a title right, they may have control over, they may have rights to use lands that extend even further beyond that. On title lands, the nations have exclusive decision-making authority. One of the things that's been raised, and we'll talk more about with the DRIPA amendments, is that we can't give First Nations a veto. They basically have a veto if they have title lands. And part of the problem here is we don't know where the title lands are. So, and if you interfere with the title lands, even unknowingly, you may have to pay compensation. You may have to set aside approvals that were there previously. This is the title lands have a high level of legal protection, but we don't know where they are. I mean, in a few cases we do. There's actually just recently, I'll talk about it a little more later, but recently been a legislation recognizing the Haida Nation's rights over most of their territory. But both the legislature and the courts have a role of clarifying the extent of Aboriginal title, but litigation is costly and time-consuming, and the courts have time after time said that the BC government and the Canadian government should be negotiating instead of litigating this out piecemeal by piecemeal in the courts. Where government knows that their actions could could impact Aboriginal rights, they are obliged to consult and accommodate the First Nations, even when the precise extent of the rights are unknown. But the stronger the basis of the Aboriginal claim is, the stronger the obligation of the government is to consult and accommodate, to the point that if the infringement is very serious and the rights are very integral to the First Nations culture, it could approach consent, the requirement of what the Supreme Court has called full consent of the nation. Legal challenges can be brought where the First Nations have not been adequately consulted or where their rights have been infringed. So this creates a quagmire of uncertainty for businesses across the province, while at the same time leaving First Nations uncertain where their rights begin and end as well. The uncertainty is not helpful for any of us. I'm going to just mention the term veto because that's come up in this. Veto is not a term that's generally used in the Canadian law. This is a political term that's being imported from the context of U.S. Presidential settings. There's various points at which monarchs have been said to have vetoes. It's mentioned in one case as in passing as something that may be present where Aboriginal title has been proved, but probably shouldn't be used where Aboriginal title has not yet been proved. But even in that case, the court talks about the importance of full consent if the infringement is serious. So the courts don't talk about veto, but when they do, they differentiate between veto and the idea of consent. So this idea that talking about First Nations consent is somehow a veto has no basis in Canadian law. It is a political conversation, in my view. Consent, rather, may involve the power to say no, but it's not a power to say no arbitrarily. It's a power to say no in the context of good faith consultation efforts and collaboration between governments. And that, I think, needs to be kept very, very separate. And, as I said, the courts have been particularly clear that where the rights are serious, where it's affecting Aboriginal title, or directly going to the ability of nations to exercise their hunting and fishing rights, those can require full consultation, or full consent, sorry. So we have a choice now to how to deal with this uncertainty. We can continue to battle it out in the courts and to litigate and do half-hearted measures to try and give nations, a bit of something so that they won't complain too much. And that's going to result in, first of all, we have to continue doing the ongoing consultation and accommodation requirements. It's going to result in delays, bad feelings, less flexibility, and costs associated with lawyers, with fighting this out in the courts. Or we can try and have another approach that works better for everybody. Now, there are efforts to sign modern treaties, and there's revenue sharing agreements, and there's other measures that governments have used to try to begin to do something that keeps these issues out of the courts and addresses the needs of the nations. But they only get us so far. The modern treaties get us a long way, but they take decades. They've taken decades to negotiate. Many nations have been in the process since I was, sort of in my early 20s, it's just crept along glacially. The Declaration on the Rights of Indigenous Peoples Act is an attempt at a new way of building a better reconciliation. The focus is on collaboration and building the capacity of the nations. There's the potential that it'll simplify the government's obligations to consult and accommodate when they can work together to develop a joint plan for a region, and then to implement that. And hopefully it results in better decisions. I mean, one of the things that's been galling about the discussions here is the assumption that if we give nations the right to be involved in decisions, those decisions will somehow be worse. I mean, I'm not sure how anyone else feels, but I don't think our government always does a great job in making decisions. And there's something to be said for a nation in relation to their territory when they have, a lot of knowledge about the area and a connection to the area, being involved in making those decisions. And it's certainly been our experience as an organization when we work with nations that those nations often bring very valuable perspectives to the table that absolutely should be included in the decisions. So moving on to the current controversy over the Declaration on the Rights of Indigenous Peoples Act and the Land Act amendments that were proposed but have been withdrawn. As Neil mentioned, BC MLAs voted unanimously to adopt DRIPA in 2019. The act primarily does three things. First of all, it requires the government to work to bring BC's laws in alignment with the principles of the United Nations Declaration on the Rights of Indigenous Peoples Act. It requires them to prepare an action plan on how they're going to do that. And then it enables BC, and I want to emphasize enables, doesn't require BC, but enables BC to enter into agreements where they will exercise a statutory power jointly with the First Nation, or will require a consent of a First Nation. And this is the point at which we've had so much controversy recently, because, and I'd like to emphasize first that, again, the incredible moment of having 100% of the MLAs in the BC legislature endorsing this legislation. Obviously the NDP and the Green Party both were on side and continue to be very supportive of this legislation. But the BC Liberal Party also ultimately, although they had questions and they raised those in the legislature and discussed them through them, were broadly supportive of the goals of the legislation and ultimately did vote in favor of it. So this is the quote from the MLA who was at the time an MLA with the Liberal Party and who is currently the leader of the Conservative Party, talking about the goals that the legislature was trying to achieve through this legislation. And he did ultimately vote in favor of it, as I mentioned. He understood why this was. So, and similarly, there was general support, if not enthusiastic endorsement, at least optimism from the business community. That this legislation would help address that uncertainty that I spoke about. So it's particularly upsetting and surprising to see something of an about face from those parties, from the BC Conservative and especially from the BC Conservative leader. His party, of course, wasn't represented in the legislature at the time, but he was there. But also from the leader of the opposition. I mean, I think it's fair to talk about the rushed consultation. I mean, the government itself has acknowledged that they did that badly. But certainly, when you start talking about an assault on land rights and the need to repeal legislation, this is not a surprise. The Land Act amendments did exactly what the BC what the DRIPA legislation committed the government to do. And it's understandable that the First Nations Leadership Council has talked about their deep frustration with this about face over legislation that previously was heralded, certainly viewed very positively by the First Nations Leadership Council, but also, as I've said, by a wide range within society. This is the provision of the DRIPA, the Declaration on Rights of Indigenous Peoples Act, that the Land Act amendments are intended to implement. You'll see that it talks about authorizing the government to negotiate or enter into an agreement for the joint exercise of the statutory power by an Indigenous governing body and the government or another decision maker, or to require the consent of an Indigenous governing body before the exercise of the power. And so this is the consultation that the government launched in January. And they said up front that the goal was to introduce this possibility of these joint or consent-based decision-making processes. It's very consistent with what DRIPA said at the time. They addressed this perception that there was a veto. But they also really emphasized this, that the purpose of this legislation was to enable possible decisions. This is a tool. This is not as it's been presented sometimes in the media or by some politicians, we are going to extend this to all corners of the province. And could we possibly deal with overlapping jurisdictions and where will people live? And this is a tool that can be entered into where it's in the public interest to do so, to address concerns of a particular nation in relation to lands that they have a particular interest, expertise, or control over, or legal rights in respect of. Now, again, this is not a surprise that there'd be consultations on amending legislation to bring in place these types of joint decision-making requirements. John Rustad, now leader of the Conservative Party, in his comments to the legislature expressly said, I've got questions about these. This will have to come forward as we look at various statutes that the government's going to amend, and we'll want to look at these types of things. Again, he certainly didn't endorse any and all approaches, but the consultation also didn't specify any approaches. At this point, all we were consulting on is how we were going to do exactly what the MLA Rustad was talking about here. The Land Act is BC's legislation for dealing with Crown land. It doesn't generally affect private land or rights. It also doesn't govern forestry, mining, or various other economic interests. It mostly relates to granting land or leases or licenses to do private activities on what is otherwise public land. In other words, it's precisely the types of granting a private interest that are most likely to infringe on an as yet undeclared Aboriginal title. So it makes a lot of sense that where you have a potential to incur liability for the province if you don't have the consent of the First Nation to act, that maybe you should be making joint decisions with them so as to avoid that. Now, joint decision-making is not defined in the legislation or by the consultation, but it was clear that it would only apply where the governments have decided it's in the public interest to do so. That's presumably going to be where they have a constructive working relationship with the nation in question. It's most likely to be entered into where nations have a strong claim to Aboriginal title or other rights, where the litigation that we've talked about and the cost and waste of resources that we've talked about is the likely alternative. It's less likely to be entered into where there's conflicting claims by other First Nations, or for that matter, where there's a high range of sort of private property interests involving ordinary people. The agreement itself will set out how decisions are made. The agreement they will negotiate with the First Nation and implement through the legislation will set out how the decisions will be made and what happens in the event of a conflict. And we've actually seen an example of this already. In 2002, the Haida Nation filed a lawsuit against the province of British Columbia, seeking not only Aboriginal title over their lands, but also claiming compensation for the financial benefits that the province of BC and the government of Canada had received from the use of Aboriginal title lands on Haida Gwaii. And that resulted, and I'm probably going to butcher the pronunciation of this, in the province of BC negotiating with the Haida Nation the Kunstagu Kunstaaya Reconciliation Protocol. It was signed in 2009 by the former BC Liberal government and provided for joint decisions between the BC government and the Council of the Haida Nation. Because the Land Act amendments we're talking about and other similar amendments didn't exist, the BC government enacted a separate piece of legislation in 2010 called the Haida Gwaii Reconciliation Act to provide the structure for that joint decision-making. Now, under the agreement that they reached, both the BC government and the Council of the Haida Nations would each select 2 representatives who they would appoint to a Haida Gwaii Management Council. And those 4 representatives then selected a neutral chair between them. And decisions were made by these 4 representatives. So it's clearly a joint decision-making function. But when people say, what happens if if the nation doesn't agree? The agreements dealt with that. If there was not agreement between the 4 representatives that were appointed, the chair got to cast the deciding vote. That structure was in place for almost 15 years while the parties continued to negotiate Aboriginal title. And that was only recently brought into place earlier this year. So the Haida now have Aboriginal title recognized through legislation as a result of negotiation, precisely as the courts have asked them to do time and again. But we had the opportunity of this joint decision-making to allow the building of relationships, the development of capacity on both sides, the gaining of information and expertise that allowed this to move towards fruition without being hung up in the courts for decades with nothing being done in the meantime. So, as I said, joint decision-making is not defined in DRIPA, but there are discussions of joint decision-making in all kinds of other legal contexts. I mean, notably, it would be really offensive in the context of parental, custody cases to announce that joint decision-making would mean that a mother or a father has a veto over their decision. A veto in those circumstances are when the process has failed. Joint decision-making requires that the parties meaningfully consult with one another and make joint decisions that are related to the best interests of the child, or in this case, maybe the territory that is covered by the consultation agreement. Joint decision-making requires that the parties are able to collaborate and work together. And if you're getting to the point where you have to say, oh, but that person has a veto, that process has broken down. That doesn't mean we shouldn't talk about that and have conflict resolution, but it is offensive to talk about, oh, involving First Nations in joint decision-making or consent is a veto, because it basically says that they're not going to engage in good faith. And these agreements will be signed where the government has confidence that they can work in good faith. So I've covered these points already, and I'm sure we have lots of time for questions and discussion, but one way or another, we're going to have to deal with the failure of BC to recognize and address the rights of Indigenous peoples. Those rights clearly exist in Canadian law, and they're either going to be litigated in a way that increases uncertainty, increases bad feelings, increases this fight, or we can do so gracefully in ways that build community, build community and have flexibility to allow us to fashion solutions that work both for the Indigenous communities and for the broader BC population. joint decision-making and the Land Act amendments that were proposed and the provisions of DRIPA that deal with joint decision-making are all intended as a tool to that goal, to that end. It's not going to be applied across the province with an automatic, whatever nation it happens to be there will be involved in joint decision-making. It'll be used as defined in DRIPA, as defined in the Land Act consultations, when the province judges that it's in the public interest to do so, and most likely where the nation has strong legal rights at stake, and therefore there's a risk of litigation. They have the capacity to work collaboratively with the BC government, and there's no other overlapping claims or other reasons that we shouldn't be using joint decision-making there. So it was with considerable disappointment on our part that we saw this tool that I think should move forward, both rushed through a consultation, which the government's acknowledged they did not give enough time for, but then also withdrawn. And we hope that the province of BC can move forward in a way that's more constructive for all British Columbians going forward. So thanks for listening to me. This is Michael works on the Marine program, so that's why there were a couple of Marines-related slides thrown in here, but I've appreciated your attention, and I'd love to have a bit of a discussion if people have questions or want to discuss this further.
Thank you very much. And we have potentially 2 sets of questions, and we have potentially 44 minutes to discuss them. There was a set of questions that was sent by you have questions, right?
I can raise one too. Sure.
So do you want to do them in sequence? You could do one question from the committee, and then we could take questions from here and go back and forth, or how would you like to do that?
I'll put my name. Hi, Andrew. It's for Craig.
Hi, Rick.
How you doing? One of the things that I think complicated the whole situation of the Land Act discussion was what was going on in the Sunshine Coast around the dock management plan. And because it was the initial attempt to try to implement this, where the government said with the Sea Shelf Nation, let's see if we can come to an agreement on how to manage the docks in the whole territory. But what happened was, what I've seen, because I've been following it very closely, was that government was talking to the nation, but most of the people who had docks didn't know what was going on. And so what happened was, all of a sudden, and I can speak of this because I have a dock there, everybody was informed that their docks were illegal. And I have a dock that's been on my property for 20 years, and I've been told it was illegal. And of course, the consequence of that was a reaction from people saying, well, what's going on? We don't understand. Nobody had talked about DRIPA, nobody had talked about these agreements. All of a sudden, people, because you talked about the implementation doesn't affect people where there are a lot of people living in the area. Well, the truth is, the early experiments in the Sunshine Coast did affect a lot of people. And the result of it was that in a matter of a month, there were 1,700 letters that went to the government from people on the coast. So my concern is that, and it's, I don't want to criticize, because it's not a criticism of the nation, but I don't think the provincial government has done a very good job of engaging local communities to understand when these things are being discussed and possibly going to be implemented. And so the reaction in the southern coast is really not at the nation, it's at the government. Because the government is seen as somehow doing this and nobody knows. And I know in my case, it was literally, I was told that my dock had been made illegal 7 years ago, but nobody told me. And I have a dock that's been on the property, there's been, and many other people, and some of these docks are $20,000 and $30,000 docks. And so I think the problem has been, is that if it's going to go forward, there has to be a way of, first of all, making sure people understand what's going forward. And then there has to be a way of involving local communities, so it's not a series of bureaucrats in Victoria that are negotiating everything. because the consequence of that has been a major pushback, like a huge pushback. And the example I said earlier was when people talked about fighting this, they raised $350,000 of donated money in 1 month to fight. Now, that's not a good situation. And again, I put the onus on the government, and I think that was the problem with the NDP around the Land Act, because people all of a sudden said it's being rushed, people don't understand what it means. And at least all the discussion on the lower coast was, we know what it means, because look what's happening here. And whether it was intended that way, it was just a happenstance, but I think if it's going to go forward, there's going to have to be a real engagement process, and there's going to have to be an opportunity for community to feel like they have a voice.
Yeah.
And it's just not bureaucrats with politicians in Victoria that are making the decision. How does that sound?
I mean, I'm not in a position to either comment too much on the dock management plan because it's not something I'm hugely familiar with, or for that matter, to defend the government, because the government does things that are, I'm always talking to people who, who have not been listened to by the government and who need some help in trying to navigate that. So, I mean, nothing you're saying is terribly surprising. I guess the questions I would have, and I did try to poke around a bit and find a little bit more about the dock management plan, but I didn't find what I was looking for. I mean, both the Fisheries and Oceans Canada and the provincial government, through their ownership of the foreshore, have long had responsibility for management of docks. This is not a new question, and yet with so much legislation, they haven't been on top of actually ensuring that, educating the public sometimes, and also ensuring that they are actually enforcing the law consistently. Some people are made to get permits and other people aren't, and the government may not realize what's going on. So the questions I have is the dock management plan, and you know more about it than I do, so I apologize if I may be exposing my ignorance here, but it seems to me that the objective of actually dealing with the sort of cumulative impact, the impact of docks over a large area and large number of properties, is something that the BC government should have been doing more systematically all along, so that landowners didn't rely on the assumption that they could do these put these docks in place. And the fact that I wonder to what degree this is being driven by the nation, and to what degree it's being driven by the fact that the government is actually trying to get its, do what it should have been doing years ago, and actually deal with some of these Land Act questions that they've been administering all along. That being said, I mean, there are clearly going to be learning curves, and I totally agree that this isn't going to work if people are feeling shut out or blindsided by inconsistent government decisions. I'm not sure if that answers your question, Rick. I would have loved to have been able to do a deep dive into the dock management stuff and be able to really come up with a more detailed answer, but that was, it's just, it seems like it's a very complicated issue, and it wasn't one I could find a lot of the documents for with the time I had.
Thank you, Andrew. I think the most efficient thing would be if somebody wants to ask a question, the first person should come and use the microphone, but then Sherry will come around with pieces of paper and pens, and if you have a question, you can write it on, because otherwise you're going to have to all troop up here, because the microphone cord is barely going to reach to the first row. So does somebody have a question that they would like to ask? Please, sir, come up.
Yes, I didn't hear too much about the DRIPA Act, so I wonder if you could talk to me about Article 26.
That's the of UNDRIP, you mean?
Yeah.
Article 26, I'm just refreshing my memory about which one that is.
So that's Indigenous peoples have the right to the lands,
That they have
territories,
traditionally
and resources which they have traditionally owned, occupied,
or
otherwise
otherwise used or acquired.
or acquired.
Mhm.
Indigenous peoples have the right to own, use, develop, and control the lands, territories, and resources that they possess by reason of traditional ownership or other traditional occupation or use, as well as those which they have otherwise acquired. And 3, states shall give legal recognition and protection to these lands, territories, and resources. Such recognition shall be conducted with due respect to the customs, traditions, and lands tenure system of the Indigenous peoples concerned. My question is, in the beginning of your presentation, you showed a big map showing where all the different nations, and this area is all, we see all the signs around here saying it's Cloud Common, the common territory. So do they own this land, all of this land? Is, I mean, according to this, that's what it is. Thank you.
Well, I mean, I think that's a question, you know, as I said, we don't yet know the extent of the Aboriginal title lands. Fortunately, most nations recognize that there are private property rights at stake, that they're not interested in displacing people from their land. So that's reassuring. What the legislation, the article you referred to and the Supreme Court of Canada both said it is, the question is, what lands have they actually been used? What did they use? What did they use? What did they have control over? There's sort of a legal test under Canadian law that I think is quite consistent with the article you're referring to about where Aboriginal title extends to. And we absolutely do need to either recognize Aboriginal title, or where that title is no longer available because it's occupied by private land, to be looking at ways of providing compensation or alternative lands. I think that there's another section of the UNDRIP that talks about a right of return if possible, right? I mean, the UNDRIP is not intended to be a prescriptive document that says you will put everything back exactly the way it was, years ago. There's a lot of language in UNDRIP that recognizes flexibility, recognizes where it's not possible to restore things to where they legally should have been, to provide compensation or restitution in other ways. So it's an important section you're referring to, BC and Canada should have processes in place to actually determine the extent and to work with the nations to determine the extent of their title lands. But what you're saying is not inconsistent at all. What UNDRIP's saying is not inconsistent at all, in my view, with what Canadian law already says. It's just that the Canadian law hasn't actually, there's other provisions about providing redress, and Canadian law hasn't been as good at that. But Canadian law in principle recognizes the rights of Indigenous people to the lands that they've used, that they owned and controlled.
Thank you, Andrew. That worked so well. If somebody else would like to come up.
I'd love to, thank you.
Hi, Andrew. My name is Bill. Now, Andrew, this is just more of an observation for you. So the natives, they have their government, they have their people. They also are turning into corporations that has a political end, and the people are shareholders. So my big question is, in our government system, we have our government that oversees corporations to make sure that they clean up their mess, et cetera, et cetera, et cetera. But if the natives are shareholders, the government and corporations, who is going to oversee them? Thank you.
Yeah, I mean, Government of Canada just bought a pipeline recently. I don't know if you heard about it. We're all shareholders in the Trans Mountain Pipeline Corporation, but
We're not. We're
well,
not.
they are. We've got the Canadian government regulating a company that they own.
Andrew,
It's off.
Andrew, we are not shareholders in that. We are taxpayers, we're Canadian citizens. but we are not shareholders in that. That's how that's set up.
The Canadian government owns it and has purchased it and now needs to sell it, and they need to sell it once it's built. So there's an inherently conflict of interest that's quite similar to what you're talking about. But the government also, of course, receives revenue from stumpage. They receive revenue from oil and gas royalties. So it's not that our system has no conflicts of interest. It's that at some point we hope and trust that our governments will regulate in the public interest. And I think it's reasonable for Indigenous people to hope and trust the same thing. But I think that we ignore all kinds of conflicts of interest involved in the Canadian legal system and then expect a level of perfection from Indigenous nations that we don't expect from our own.
Oh, no, Andrew, that's not what I'm getting at. Andrew, what it is who is overseeing Indigenous people? Like, there has to be somebody that says, our government is supposed to oversee Singapore. Oversee, make sure that they clean up their mess. Now, if you have a group of people that are the shareholders, they are the government and corporation, that is a conflict of interest. We've never seen that in history. I like history, but even the kings and queens didn't have that.
I mean, I still think BC Hydro is another example of government owning, regulating itself. That being said, if we're concerned about that, absolutely. I mean, BC remains the legislative body and the body that's responsible for regulating what goes on the land. And if we're concerned about conflict of interest, having Indigenous nations be able to make decisions that affect BC Hydro or the Trans Mountain Corporation may actually reduce the conflict of interest on our end too. So joint decision making in those circumstances absolutely can play a valuable function, I would think. But I do think that there's a certain level of, we see the potential for conflicts in other people more easily than our own system.
Thank you, Andrew. I have my first question on a card. The question is, can you comment on changes to parks such as Joff Lake and others?
I'm sorry, I didn't quite hear the question. Can you repeat it?
Can you comment on changes to parks such as Joffre Lake, Joffre Lake,
And Garibaldi Lake as well.
and Garibaldi Lake as well?
So I'm not familiar with those specific changes. There has for many years been, the BC government has had a policy about when they will consider changes to park boundaries, and it's one that we've been quite critical of, because it seems to us that there's a history of modifying park boundaries for commercial interests, which parks are intended to protect against. But I'm not familiar with the particular boundary amendments or changes that are being referred to in the question.
Not a boundary thing, may I speak to that then? Can I come up and?
Yeah,
Please.
Yeah, and I could be wrong here, feel free.
Yeah.
Are you the person who brought the card?
Yes. Hi, Andrew. Now I may be completely off base and might not have anything to do with what you're talking about, but Joffre Lake is a BC park, right? In Garibaldi. And last September, I believe First Nations closed the gate and didn't allow visitors to come in. It's some sort of, there's a dispute going there, and now I see there were being modifications in who can use the park when. And that allows, I'm thinking, a certain chunk of time for First Nations only to come onto that land.
Correct. 2 weeks closed in May, 2 weeks in June, and September 3rd to October 3rd.
Yeah, 2 weeks closed in May, 2 weeks closed in June and October or something. Does that come under what you're talking about?
It may. Again, I'm not familiar with the circumstances of it. If to the extent that the nation has Aboriginal rights in the park, there may well be a constitutional obligation on the government to seek ways to accommodate that. I mean, I guess it's also worth mentioning at this point that there's been a drive to actually increase areas protected as parks through Indigenous protected areas, where nations are declaring their own parks and then pressing the BC government to recognize them. So there's been you know, we're definitely in a period of some big changes in terms of how parks are used and what they you know, how they're managed and how they're created. Many of these parks were created in areas that were of cultural or other significance to nations without any consultation when they were created. So there are issues that definitely need to be addressed there. I'm not familiar with the specifics in these cases.
Thanks.
I have a question, Andrew. It's on a card. It says, should Canada, brackets federal, so I assume it's saying, should the federal government not be dealing with the Indian Act first? And then there is a star, all people should be equal. So should Canada not be dealing with the Indian Act first because all people should be equal?
So, I mean, the Indian Act has obviously a long and ignoble history of both replacing Indigenous governments and keeping Indigenous people confined to reserves, it's a long and complicated history. There have been some improvements made, obviously, but there's still a long way to go. I don't think either is a constitutional matter in terms of the government's obligations to address issues of title and the impacts on Aboriginal rights of government actions, or as a moral matter that we can just go, well, we can't start solving these problems and recognizing that there is an existing these rights continue to exist and that they have an effect on what we're doing now until the federal government's got its act together. I mean, BC is the one causing harm in these on these lands or doing things that will affect the culture and rights of the nation. Both levels of government need to be doing better. And I mean, I don't think the comment equality, I'm not quite sure what is, I mean, there's a long history of First Nations not being treated equally. Part of the reason that the case law has developed as it has is because there was a recognition that treating people equally means recognizing the rights, the legal systems of the Aboriginal people. The Supreme Court of Australia in the Mabu case, which came out in 1992 and has been quoted positively in Canadian cases and influenced the Delgamuukw case and others. The court talked about the fact that the rule of law means that we apply the law equally, no matter who's at stake, and that means that we can't say that in that case Australian law trumps Aborigine law. These laws both have status, and the idea that one of them is more valid than the other is troubling from the point of view of rule of law and equality. Yes, equality is important, but there are different ways of viewing what equality means.
Thank you, Andrew. I don't have another card.
I got a question. Hi, Andrew. How you doing?
Hi.
Okay, this is with regards to Article 28. Indigenous peoples have the right to redress by means that can include restitution, or when this is not possible, just fair and equitable compensation for the lands, territories, and resources which they have traditionally owned or otherwise occupied or used, and which have been confiscated, taken, occupied, used, or damaged without their free, prior, or and informed consent. So my question is, my property that I have registered at Land Title Office, okay, that's in my name. Am I at risk at losing my property because I don't know which lands that they are gonna claim? Are they gonna claim all of Powell River? Are they gonna claim just the shoreline? Are they gonna claim just the harbor? What are they gonna claim? Because right now, we don't have a treaty. Right now, it's all open up in the open. And we are in the dark here. We don't know what they're gonna claim. We could all lose our properties. So where are we at?
So I appreciate the question because I mean, obviously, it's so important to us to know we have someplace to live and own our land. The reality is that none of the land claims that have been filed have sought to to recover private lands. There have been a handful of disputes where particular private properties, especially like larger properties, have particular historic value for nations, but those haven't been through the courts. It's been more sort of, well, for the most part. But individual residences have never been targeted in a First Nations claim in Canada, as far as I'm aware. The UNDRIP provision you're talking about says that if the government is not able to provide the lands back, that the government has to give redress. It's not talking about you having to pay up. It's saying that the government has responsibility for ensuring that where it has given land away that maybe was subject to Aboriginal title to private interests, that it's responsible for ensuring this restitution or redress. That's not about you losing your property. And there would be uproar if the government or nations were to try to take back those lands. So I think you can feel fairly confident that you will continue to own your property. But it's an understandable concern because we are in uncharted territory here. But yeah, I mean, I'm not. I also own land in Victoria, which is, I guess, subject to one of the Douglas treaties. But it's given the same concerns could come up anywhere. It's not. I don't think it's a reasonable fear, but I don't think it's based in the reality of what we've seen or where the law or UNDRIP goes or has gone.
Andrew, I have a very complicated question here, so I'll repeat it if you need. It is regarding UNDRIP and DRIPA. Has the BC government actually committed through DRIPA to literally implement all of the articles of UNDRIP, or is it aspirational, centered on core principles is underlined, like the right of Indigenous peoples to survive and flourish as a culture and people? Do you want me to repeat it?
No, I got that. Thank you. I think there is a sense in which it is aspirational. I think that's quite perceptive. I mean, it does sort of say, it should pull the actual language up, but it does talk about DRIPA being, or UNDRIP being part of the legislation. But the reality is that if you read through UNDRIP, it can be interpreted and implemented in any number of ways. The purpose of the Act is to affirm the application of the Declaration to the laws of British Columbia, to contribute to the implementation of the Declaration, to support the affirmation of and develop relationships with Indigenous governing bodies. There is, the Act does that, as I mentioned, in three ways. One is to say that they will amend laws to try to implement these things. But if you look at it, there's a whole waft of articles. They have discretion in them about whether you deal with concerns through restitution or compensation or through return, the types of institutions that are set up. All of this has to be done based on the government's discretion and in consultation with First Nations. So it's very much aspirational from that point of view. Secondly, they have to have a plan about what they're doing. So that, they need to say this is how we're intending to do this. And then thirdly, they have the option of using this tool of entering into joint management agreements. The more interesting question in terms of the legal effect of this in the short term is, to what degree will the Canadian courts start looking to UNDRIP to interpret the constitutional obligations in court cases that come before them? And we don't yet know the answer to that. There's an initial court case that says it's not directly enforceable, but that's a lower court case. And even if it's not directly enforceable, I think it almost certainly will be an aid to interpretation that the courts will look to. But I think in principle, yes, I agree that there's an important way in which, I'm not sure whether aspirational is quite the right word, but it can be seen as aspirational, but it's certainly not automatic, because the UNDRIP can be interpreted in so many different ways, and the government's just committed to work towards that.
Thank you, Andrew. I don't have any more
Yes,
cards.
two.
No, I do.
Double checking, and then there's one more being mixed up.
And if it comes too slowly, then somebody's welcome to come. So this question is, can you comment on how UNDRIP aligns or does not align with the Canadian Charter of Rights and Freedoms, specifically Haida Gwaii Aboriginal title over all land and public's right to vote? I can read it again.
No, I think I got it, and I'm wishing that I was more an expert in this field than I am, because there was a recent court case that I'm trying to remember the details of that actually looked at the application of the charter to an Indigenous government. And I'm drawing a blank on the name of it or even some of the details. So I apologize. But at its broadest level, the court found that the charter did apply to the nation. It related to whether or not a nation could restrict its members, the members' ability to vote to those who were actually on reserve, I believe. The charter did apply, but that a majority of the court felt that it did not. There was no violation in that case because of the specifics of the case, and they suggested that this sort of approach to interpreting when violations might occur might be slightly different. And I'm afraid I don't remember anything more than that. So it was a recent case, and I was actually on holiday when it came down. I don't think I ever got around to going back and reading it. The question of the ability of people to vote. I mean, obviously they continue to vote for their, for non-Indigenous people will continue to vote for their elected representatives who, on lands that you are not, that aren't covered by title or are not yet recognized by title, will at least, even on a joint decision-making process, will have a role in making the decisions. In terms of title lands, it is an interesting question. I mean, we have, like, landlords have a huge level of control and are not subject to the charter at all over the people that they rent to. The idea that a landowner has control over what goes on their land is covered. Now, under the Haida agreement, the Haida title agreement, private property is exempted from the title claim, so they continue to have a role there. But the Haida have I believe, an increased governance role too. So it raises complicated questions, but the idea that a landowner does have control over what goes on their land, even over people who live there, continues to be there. The Haida Gwaii Act is an act of the BC legislature. The Haida Gwaii Title Act, rather, is an act of the BC legislature. So the BC legislature does continue to have an oversight role and a control role as they would over other pieces of legislation. But we're definitely moving into some interesting territory. As I said, the private lands were explicitly exempted and are protected under that legislation.
Thank you. I have a card. It says, have any countries that have signed UNDRIP reversed themselves to no longer be a signatory? And it occurs to me that we have somebody hoping to be prime minister who threatens to use the notwithstanding clause. So I wonder if he could do it too.
Is that on the question?
Have any countries that have signed UNDRIP reversed themselves to no longer be a signatory?
I'm not aware of any, but I actually have never really looked for that, so I wouldn't want to be quoted as saying. On the notwithstanding clause, oddly enough, the Section 35 rights, the protection guaranteed to Indigenous populations is not part of the charter, and therefore is not subject to the notwithstanding clause. I'm not sure why it was drafted that way, but that is my understanding at any rate.
We have any more questions? Please, sir.
It's just following along with the Haida Gwaii I was in Vancouver a couple of weeks ago and stuck for weather at the airport. And one of the gals at the same hotel was from Haida. She had convinced her two adult children to leave. She'd lived there for 30 years, so her counselor, she's gonna stick it out. She had no idea how she was gonna retain title over her land. Because the Land Title Act is not gonna apply on Haida.
Ah, there you go.
So are they gonna lease their property and pay annual lease payments to First Nations, or how do you foresee it playing out?
Okay, my understanding, but I have not actually read the Haida Title Act in any detail, but my understanding was that the private lands continued to be treated as private through the under the legislation. I would have to go back and look at the legislation to see the specifics of that.
They could change it.
Anybody else?
Asking follow up.
Follow up?
Follow
Okay, so, but they could change the legislation, right? We can wind up, fine, right now we're registered at land titles, right now, and our homes are registered at land title, but that could be all taken away if they change the legislation, could it not?
I mean, that is generally true for anything. I mean, the BC government can change legislation, whatever legislation it likes. There's no reason to believe that it's intending to do so. And as I said, there'd be a huge backlash if they did do so. So I don't see, I mean, yes, I mean, but they could equally legislate, I don't know, all kinds of things as long as they're not actually violating the charter. So it seems to me to be a fear that's based on a lot of speculation.
Ask him, would that violate the charter?
Sorry?
She wants to know if that would violate the charter.
The charter has not generally been interpreted as protecting private property rights.
Oh, there you go.
But the Bill of Rights has.
Somebody is saying the Bill of Rights has, not the charter, but the Bill of Rights.
That's a federal piece of legislation, only applies to federal. Oh, you mean the US Bill of Rights?
No, the Canadian of 1960.
Canadian one, but that applies to federal decisions. It wouldn't apply to the province. Again, no one is talking about getting rid of anyone's private rights. The question is almost entirely in relation to where are we recognizing Aboriginal right on what's currently viewed as Crown lands, and potentially around compensation where there are not lands available for a treaty or settlement.
We have 8 minutes left before the library is going to kick us out. So if anybody here has a burning question and they're holding back so that other people will have a proper chance, this is your chance not to hold back.
Sure, I'll throw one out.
Somebody else.
Hi there. So how can approximately 4.7% of a population in BC and about the same percentage in Canada have so many rights over the other 95.3% of the population that owns our own properties, owns our own lands, goes out and hunts in these areas, goes out and fishes in the ocean. We buy our permits, we buy our licenses, but they, for some reason, have more say at this time. And our left-sided governments are listening to them and bending over backwards for those people that are pissing us off.
So, I mean, I know this isn't a fair counter example, but in Fiji, which is another British colony, the indigenous, the tribes, the tribal chiefs there have a sort of essentially act as the Senate for the country. The decisions that are enacted by the parliament have to go through a body of indigenous leaders. In New Zealand, there was a proposal, it was defeated. It was New Zealand or Australia, but sorry, I should know this. There was recently a proposal, I think it was Australia actually, to introduce an indigenous voice that would speak directly to Parliament on behalf of Indigenous peoples. Countries around the world are grappling with this question of where we've ignored the legal rights of a whole people, to the point that, I mean, First Nations in many cases have trouble getting potable water on the reserves. In many cases have very limited resources. When we've ignored their rights for years, to say, oh, now they are suddenly getting more attention, and have more status than us. I mean, I think that's a misread of what's going on here. I mean, there are lots of corporations or legal structures in Canada that have a ton of power over a ton of area, and we don't blink twice at them. Whether it's forest companies or municipal governments, or these institutions have a lot of control over our lives. And now, for the first time, First Nations are increasingly saying, "Hey, our laws were never repealed, our title were never repealed," and for the first time, governments are recognizing that. And yeah, it's a challenge, but this is the path we set ourselves on when our country was founded, and we didn't deal with these issues then.
Thank you. Not all of us are racist in this room. Thank
You
you.
struck a chord, Andrew. You got claws.
One last question for me. Point of order.
Yeah.
If you had the chance, you yourself, yes or no question, and you had the ability to get rid of UNDRIP or DRIPA because it is harming to everybody, would you do it?
I don't believe it is harming everybody, so no. The reality is, DRIPA does not do much that Canadian constitutional law does not already do. What it does is that it does it in a clearer way, a way that we can point to and actually implement it. If we got rid of DRIPA, sooner or later, most or all of those rights would be recognized by the Canadian courts, but it would involve a whole lot more litigation and pain to do it.
Thank you, Andrew. We have 4 minutes. Is there anybody who hasn't asked a question yet? Please.
Thank you. It's not so much a question as a comment. And first, I want to just thank the Westview Association for organizing something like this and making it open for anyone to come. And credit to you. And secondly, what is your organization doing, Andrew, to create the opportunities for people to learn more about their own history, the differences of view and perspective that people have? And clearly, it touches a lot of hot points. Some of the legislations, decisions, but there's a big wave of history that you have pointed out. We've been dealing with these issues for many years. We're going to continue to grapple with them in the future. How do we make it a better place for our kids and the generations after them?
Thank you. Good question.
Yeah, thank you for the question. So Westcoast Environmental Law has been, I didn't say enough about it when I started, I think, in terms of introducing myself rather. We've been around since 1974, and we've worked through that much of that period with a very strong emphasis on Indigenous rights and recognition of Indigenous title or Aboriginal title and Aboriginal governance. We have a program called RELAW, which stands for Revitalizing Indigenous Law for Land, Air, and Water. Doesn't quite work as an acronym, but that's how we do it. I do not work on that program, but my colleagues who do are working directly with nations to help identify principles in Indigenous law that can be used and adopted in Canadian law, and to translate it in ways that the Canadian legal system will understand to better protect the environment in those nations' territories. And so there's a lot of resources on our website about that. We also have a blog that talks about a number of issues, including the the DRIPA Land Act controversy, which is, I think, why I was asked to, or we were asked to speak at this. But I think we'd also point you to, to the resources that are available from Indigenous organizations who, of course, have more direct experience with this, whether it's the Assembly of First Nations or the Union of BC Indian Chiefs or other organizations that have a lot of information about the history of the dispossession of Aboriginal people. Yeah, I'm sure there's more we could do in terms of public education on this. We were pleased to be asked to do this, but it's something that Michael and then myself, I completed Michael's presentation because we were asked to do it. It wasn't something that we necessarily sought out to offer as a educational piece, and maybe we should do more of that.
Andrew, I'd like to thank you for your presentation tonight. You've been really good and not just a utility infielder brought in because of an injury. You've been a real home run hitter tonight. And had you been here in person, I would have hoped to present you with a bouquet of flowers, but since you're here on Zoom, you'll have to take it as aspirational.
Thank you very much, everyone, for coming out and for the great questions.
Thank you.